U.S. laws for importing and exporting wine. Global Wine Marketing online course, SUNY Cobleskill, Ketchkamate College. The TTB, or Alcohol and Tobacco Tax and Trade Bureau, oversees the importation of beverage alcohol products into the United States for commercial use. Under the Federal Alcohol Administration Act, any person engaged in the business of importing beverage alcohol products into the United States for commercial use must have an importer's basic permit and obtain a certificate of label approval, or COLA. The importer must also pay a federal excise tax and any applicable duties to U.S. Customs and Border Protection. For alcohol importers, you must submit a supplier agreement or a letter of intent to supply from a foreign supplier of alcohol, which serves as evidence of your intent to engage in the business of importation. If you intend to bring back a substantial quantity of alcohol for your personal use, you should contact the port through which you will be entering the country and make prior arrangements for entering the alcohol into the United States. It may also be useful to contact the carrier you plan to use, as many have strict guidelines regarding the shipment of alcoholic beverages. Some states prohibit the direct shipment of beverage alcohol products to individuals. We recommend that you check the state government before you go abroad regarding their personal importation policies and additional state taxes that might apply. Individuals interested in importing alcohol for personal use should contact their state liquor control board. You can bring back alcohol for personal use or as a gift. Generally, 1 liter of alcohol per person may be entered into the U.S. duty-free by travelers who are 21 or older, although travelers coming from the U.S. Virgin Islands or other Caribbean countries are entitled to more. Additional quantities may be entered, though they will be subject to duty and federal excise taxes, which will be assessed and collected at the port of entry. Alcoholic beverages purchased in duty-free shops are subject to duty and federal excise tax when accompanying you into the United States. Note, federal excise tax rates are for informational purposes only, as actual tax or fee may vary according to a person's circumstances. It is not legal for travelers under the age of 21 to import alcohol, even as a gift. Most states' restrictions on the amount of alcohol that can be brought into that state apply only to the residents of that state. Usually, people transiting through a state are not subject to those restrictions, but sometimes regulations change, and if this is a matter of utmost importance to you, you can check with the State Alcohol Beverage Control Board, or ABC, where you will be arriving, to find out what their policies are. There is no federal limit on the amount of alcohol a traveler may import into the U.S. for personal use. However, large quantities might raise the suspicion that the importation is for commercial purposes, and a CBP, or customs officer, could require the importer to obtain an Alcohol and Tobacco Tax and Trade Bureau import license, which is required for all commercial importations, before releasing it. So, a general rule of thumb is that 1 case of alcohol is a personal use quantity, although travelers are still subject to state restrictions, which may allow less. In New York State, you may import less than 90 liters of liquor into New York during a 1-year period for your personal use without being registered. You may need to obtain a special license to import liquor for your personal use. A special license allows you to import liquors into New York State without posting a bond. These conditions apply. You must have a special license if you're importing between 90 and 360 liters of liquor during a 1-year period. USA Today offers these tips for bringing back wine when traveling, since wine is not a typical souvenir. Because of Transportation Security Administration, or TSA, rules, Wine is not a common carry-on, although you can take wine purchased inside the terminal in your carry-on luggage. All other wine must be packaged and shipped with your checked luggage. Taking wine on your flight requires advanced preparation, but when you arrive at your destination and crack open your favorite bottle, you will be happy you made the effort. Items you will need: styrofoam container, wine skin, cardboard box, packaging tape. Taking wine as checked baggage. Step 1. Invest in solid styrofoam packaging or a wine skin from a local wine store, as well as properly sized cardboard box for the wrapped bottles to rest in. Step 2. Wrap your bottles in the packaging, then place them in the box. Once you have packed it, the box should be full, with no room for the bottles to slide around. Step 3. Seal the box with packaging tape. Step 4. Write your name, address, and flight number clearly on the outside of the box. Step 5. Set the box packed with wine on the scale when you check in for your flight and tell the check-in agent that the box contains wine. Step 6. Pay the checked luggage fee based on the total weight of your wine box. Taking wine into the cabin. Step 1. Pass through the security checkpoint with only your approved carry-on liquids. TSA regulations require you to fit all of your liquids into containers no larger than 3.4 ounces. Step 2. Browse the terminal for wine stores once you pass through security. Wine purchased after you pass the security checkpoint already has been screened, and the TSA allows passengers to take these liquids on the plane. Step 3. Keep your wine safely in the overhead bin or underneath your seat, always making sure to insulate the bottle from any hard shocks with a jacket or wine skin. Here you see the different types of permits required for importing or exporting alcohol. An alcohol exporter permit, an alcohol importer permit, which allows you to subsequently distribute it for sale, a wholesaler permit, which is for businesses that sell alcohol at wholesale rates to other wholesalers or retailers. A wholesaler permit is also required for someone who produces or manufactures alcoholic beverages only if they will sell alcohol products not produced or manufactured by them. And a wholesaler/importer permit for businesses that require a basic permit for importing and distributing foreign alcoholic beverages, and for distributing domestic alcoholic beverages as a wholesaler from the same location. The TTB has a safe, secure system to apply online for a permit. You can submit and track most application types online. They also offer a tutorial that gives overview of the steps involved in starting a new business that will be regulated by the TTB. That tutorial is the other PowerPoint assigned to watch with this one. Wine business permits. To obtain official permits, you will need to complete these steps. Identify what type of wine operation you want to start and fill out the proper permit. You submit the completed application to TTB's National Revenue Center, where it will be reviewed. You might have to have a telephone interview or make some changes to the application. You will also need to provide identification of yourself as the applicant, identify the nature, location, and extent of the premises where you'll be conducting business, identify the specific type of operations that will be conducted on the premises. The United States has two different levels of governmental jurisdiction: a federal government with federal laws that apply to every state, and 50 different state codes of laws. State law cannot contradict U.S. federal law, but state laws on wine imports and distribution can and do vary widely from state to state. New York is a licensure state. Private sellers must have a license from Alcohol Beverage Control, ABC. 32 states, which include New York, California, Texas, and Florida, are called licensure states. These states issue licenses to private sellers. State agencies can place conditions on these licenses, which help the states more indirectly control the sale of alcohol. 18 states representing approximately 25% of the U.S. population, directly regulate alcohol sales by controlling its retail and/or wholesale distribution. These states are called monopoly states. In these, the state has a monopoly over the wholesaling and/or retailing of some or all categories of alcoholic beverages, such as beer, wine, and distilled spirits. Most of these states have different levels of regulation depending on the type of alcoholic beverage, with a number of them exempting wine and beer from the state monopoly altogether. So, in those states, wine and beer are sold in supermarkets, but liquor, distilled spirits, etc., are sold in state-run or state-contracted liquor stores. In New York State, minimum requirements for eligibility to hold a license are: applicants must be U.S. citizens or have permanent resident alien status. In some cases, citizens of countries with reciprocal trade agreements may apply. Applicants must be 21 or older. Applicants must not be convicted felons unless they have a certificate of relief from civil disabilities. Applicants cannot be a police officer with arresting powers. New York State, through its alcohol beverage control law, also regulates prices. The New York law requires a wholesaler to register on a monthly basis a list of the prices that the wholesaler has decided to charge other wholesalers or retailers for its products for that month to the New York State Liquor Authority, allowing for a downward reduction to meet competitors' prices. The statute does not, however, authorize anyone to determine retail prices for wine, nor does it bind wholesalers to the prices they may charge their own dealers. Setting up a wine corporation in the United States, step by step. 1. Define a commercial strategy including short and long-term objectives. Select which of the states you wish to market your product in. Generally, it is recommended to start out with a maximum of 3 states. 2. Obtain necessary funds for setting up an office in the U.S., employment expenses, etc. 3. If you are a business outside the U.S. seeking to create a U.S. wine corporation, register your foreign entity with the Department of State as a foreign corporation, or you can create a new limited liability company, which is a type of corporation, in the U.S. and obtain its employer identification number, EIN. The last option is the preferred choice. 4. Open a bank account and have some funds deposited for startup expenses. 5. If you have staff members who are not U.S. citizens, apply for a visa and work permit for every foreign member of the staff. 6. Locate and rent an office. 7. Apply for a federal import license. 8. Register your trademark. 9. Before you start shipping into the U.S., hire a customs agent and establish a customs bond. Register your foreign entity or U.S. company with the FDA. Comply with TTB's labeling requirements, meaning obtain COLA certificates, because the TTB must approve every wine label imported into the U.S. Comply with the country of origin certification requirements for imported wines. Obtain a wholesaler's distribution license in every state you are targeting. Locate sales agents who will promote your products. Negotiate contracts with your sales agents, setting forth the rights and obligations of each party. 10. After you have started to ship, evaluate your initial sales to determine whether to expand to additional states. Here we see product packaging with regard to mandatory labeling items. When creating a wine label, there are several mandatory items that must be included. Some of this mandatory information must appear on the brand label, while other mandatory information may appear on any label. Additionally, there are minimum print size requirements based on the size of the container. Label requirements. The brand name is the name under which wine will be marketed and sold. It is generally the most prominent name that appears on the label. If there is no brand name, the name of the bottler or packer may be used if it is shown on the designated brand label. The brand name may not create a misleading impression. The brand name must appear on the designated brand label. On the sample label at the right, Lighthouse Cellars is the brand name. Brand labels, class and type. For other than standard wine, which includes wine to which a flavor or color has been added, a truthful statement of composition must be used as the class or type. Wine that is not standard requires a formula approval by the TTB, and they will give an appropriate statement of composition when the formula is approved. The class or type must appear on the brand label. On the sample label at the right, the varietal Chardonnay is the class type. There are 9 classes of wine. They include grape wine, sparkling grape wine, carbonated grape wine, citrus wine, fruit wine, wine from other agricultural products, aperitif wine, imitation wine or other than standard wine, Retsina wine. Brand labels. Alcohol content. The alcohol content of the wine must be shown on the brand label, and it must be written as a percentage of alcohol by volume. Table wine may be used instead of showing specific alcohol content, but only for wine between 7 and up to 14% alcohol by volume. The same is not true for dessert wine. Dessert wine always requires a statement of alcohol content. Alcohol content may be shown as a range, but the range can be no more than 3% for table wine and no more than 2% for dessert wine. At no time can that range cross into another tax class. For example, a range of 11 to 14% is acceptable, but a range of 13 to 15% is not acceptable, since you have crossed from table wine into dessert wine. Abbreviations can be used, ALC for alcohol and VOL for volume. Brand labels, appellation of origin. An appellation of origin is mandatory and must appear on the brand label if any of the following appear: a grape varietal, a vintage date, a semi-generic designation, estate bottled or grown. If mandatory, the appellation of origin must appear on the brand label. On the sample label at the right, Hudson River Region is the appellation of origin. Any label. In addition to the brand label requirements, there are additional mandatory items which must be included on any label, and these mandatory items include the bottler's name and address. The name of the bottler, city, and state must appear on every wine label exactly as they appear on the basic permit. The statement must be preceded by the phrase bottled by or packed by. There are also optional terms that can be used if so desired, such as produced by, vinted by, etc. The bottler's name and address may appear on any label. On the sample label at the right, produced and bottled by Lighthouse Cellars, Kingston, New York, is the bottler's name and address statement. In this example, it is located on the back label. Net contents. Wine may only be sold in authorized standards of fill and must be shown in metric standards of fill. There's a list of authorized sizes. The container size may be shown on the label, or it may be blown or branded into the bottle. For containers under 1 liter, the net contents must be shown in milliliters, or ml. For containers 1 liter and larger, the net contents must be shown in liters, or L, and decimal portions, for example, 1.5 L. The net contents may appear on any label. On the sample label at the right, 750 ml is the net content. In this example, it is located on the back label. Sulfite declaration. The sulfite declaration is required if the total sulfur dioxide or a sulfiting agent is detected at 10 parts per million or more. Common statements include contains sulfites and contains a sulfiting agent. Other similar appropriate phrases are also acceptable. The statement may be omitted if a laboratory analysis determines that the sulfite content is less than 10 parts per million total sulfur dioxide. Such analysis may be performed by TTB or by a TTB certified laboratory. The sulfite declaration may appear on any label. On the sample label at right, contains sulfites is the sulfite declaration. In this example, it is located on the back label. Health warning statement. Any alcoholic beverage containing 0.5% alcohol or higher is required to have a health warning statement on the label. The health warning statement must appear on all wine containers for sale or distribution, must be legible and appear on a contrasting background, and must appear separate and apart from all other label information. The words government warning must appear in capital letters and in bold type, and the rest of the warning statement must not appear in bold type. The S in surgeon and the G in general must also be capitalized. The following is the required language for the health warning statement. Government warning. 1. According to the Surgeon General, women should not drink alcoholic beverages during pregnancy because of the risk of birth defects. 2. Consumption of alcoholic beverages impairs your ability to drive a car or operate machinery and may cause health problems. The health warning statement may appear on any label. The health warning statement is shown on the sample label at the right. In this example, it is located on the back label. Any additional label information must be truthful, accurate, and specific, but not misleading. May not conflict with or qualify other mandatory information, and must comply with the corresponding selections of the regulations. Unbelievable. COLAs, or certificates of label approval. When are COLAs needed? A certificate of label approval, COLA, is required for all wine distributed in the U.S., domestically produced as well as imported. The application must be submitted and approved before the label can be used. It is the bottler's responsibility to obtain a label approval prior to bottling. All labels must be affixed to the bottle prior to removing the wine from the bonded premises. When is a new COLA needed? Once a COLA has been approved, certain changes can be made to the label without filing a new COLA, such as change in vintage year. Other changes, such as varietal designations, do require a new COLA. For many alcohol beverage products, TTB requires a product evaluation to determine whether a proposed label identifies the product in an adequate and non-misleading way. Pre-COLA product evaluation entails a review of a product's ingredients and formulation, and also may include a laboratory analysis of the product. Laboratory analysis involves a chemical analysis of a product. Such pre-COLA product evaluations ensure that no alcoholic beverage contains a prohibited ingredient. Limited ingredients are used within prescribed limitations or restrictions. Appropriate tax and product classifications are made. Alcohol beverages labeled without a sulfite declaration contain less than 10 parts per million of sulfur dioxide. The type of pre-cola product evaluation necessary for a particular product depends on that product's formulation and origin. TTB regulations require formulas, usually when flavoring or coloring materials are added. Field investigations can be used to verify the accuracy of these documents. Since TTB does not have access to foreign plants, some imported products are subject to laboratory analysis or pre-import letter approval. The three-tier distribution system. Under the so-called three-tier distribution system widely in effect throughout the U.S., including in New York, the individual states, through their Alcoholic Beverage Control, or ABC, agencies, license and regulate three groups of alcoholic beverage players. Tier 1 manufacturers or importers sell their products only to Tier 2 licensed beverage distributors or wholesalers, who in turn sell only to Tier 3 properly licensed retailers, including bars and restaurants. Those in Tier 3 have the right to sell alcoholic beverages to customers over the age of 21 in areas where alcohol sales are allowed and only after the proper collection of taxes. In some states, including New York, in addition to a basic importer's permit, federal TTB issued importing license, to import wine, the New York State Liquor Control Authority also requires that each such importer also holds a wholesaler's wine license. The purpose of the three-tier system is 1. To clearly define the authorized channels through which alcohol enters each state, and 2. To establish guidelines that state regulators and law enforcement can monitor. The combination of these is to ensure the safe distribution of alcoholic beverage products to consumers throughout the United States. Before 2005, the New York laws stated that a non-New York winery had to be physically located in New York in order to be able to ship wine directly to consumers, and this was ruled to be unconstitutional by the U.S. Supreme Court and was no longer allowed. Importers, distributors, and retailers each must have a specific license. The importation license is issued by the federal government and is valid for the whole United States. The distribution and retail licenses are issued by each state and are valid only within the state that issues the license. So an imported item must have at least one importer at the national level and can be distributed by several distributors located in the different states where the product is going to be marketed. However, some states restrict wholesalers to work with only one distributor in that state. Changing distributors can be difficult once a relationship is established between a wholesaler and a distributor. Wholesaling licenses for importers in New York State. What basic requirements are necessary to be a wholesaler in New York State? TTB will allow operation through a home office as long as access to that office is available 24/7, but some states, including New York State, do not allow a home office and will require an office address before they will issue a wholesaler's wine license. The licensee must have an office in New York State. The office must be physically separated from other premises. No other business may be conducted on the licensed premises. There must be an employee present during regular business hours. Books and records must be kept on the licensed premises and available for inspection during regular business hours. The licensee must be a U.S. citizen or have a green card. Warehouse can be located anywhere. However, if it is located in the same building as the licensed premises, it must have a separate entrance. If the licensee wishes to import alcoholic beverages from another country, A federal importer's permit is required, which can be obtained from the TTB. European companies can directly import their wine and liquor into the United States. There are 3 different options to import wine and liquor into the United States. 1. The first option is to import directly by setting up a separate corporation or a corporate subsidiary in the United States, or having the foreign winery itself become authorized to do business in the United States. The second option is to sell the wine to a classic importer that will resell the wine through its own network of distributors. Most wineries exporting to the United States employ a classic importer. This is the most expensive way to import. It is also the fastest way to get your wine into distribution in the United States, since the importer is in charge not only of importing, but also of selling via distributors, which the importer locates itself. The winery is not required to obtain any licenses, since the importer is already licensed. The winery must only provide the necessary letters of authority required by the national importer or the importer in each state. Secondly, the foreign winery contracts only with the importer, and the importer will find his own distributors who will sell the product to the retailers, the bars, the restaurants, and shops. The third option is to export through an alternative importer that focuses on the logistics, the administration, and compliance. That importer will import, warehouse, and distribute the wine using a brand manager chosen and employed by the winery to sell the wine. Unlike the classic importer, an alternative importer will only offer you an infrastructure through which you can export your wines into the United States market. You will sell them at an agreed upon price. You receive payment when the sales agent sells the wines to distributors, and payments are paid to the alternative importer. The alternative importer has a licensed wine warehouse where the wine is stored until it is sold. The advantage of this importing method is that the winery has a direct link with its sales force, because the importer allows the winery to relate directly to its distributors. On the other hand, this method requires the winery to locate and hire its own sales force to find buyers in the different states. Payment to the winery's sales force may be made through the alternative importer if the winery prefers to do this. A recent change in U.S. law, the Bioterrorism Act. The Public Health, Security, and Bioterrorism Preparedness and Response Act of 2002, otherwise known as the Bioterrorism Act, requires that the Food and Drug Administration, or FDA, receive prior notice of food imported into the U.S. Alcoholic beverages are classified as food and therefore are subject to the requirement of prior notice. Importers as well as wine producers must register with the FDA and notify the FDA every time a shipment is to come to the United States. It is possible to register on the internet, and the registration must include the following information in English: the name and address of the entity that is registering, the name and address of the person to contact in case of emergency, trademarks and trade names, the name and address of the U.S. representative of the registrant in the United States, a detailed list of the producer's products. Registration with the FDA is free. Nevertheless, you must have an agent who will act as your company's representative with respect to FDA matters. That agent must be available at all times, day and night. U.S. Interstate Wine Trade. Each state has created its own system of alcohol regulations. These various systems have been influenced by local business interests and regional political attitudes. As a result, the laws governing direct shipment vary widely, ranging from quite open and simple to states that consider wine shipments a felony. Reciprocity is a legal concept that basically says a winery in your state can ship to a consumer in my state only if a winery in my state can ship to a consumer in your state. The Supreme Court ruled in 2005 that reciprocity is a violation of interstate commerce law. This is why, as of July 1st, 2011, there are no longer any states in the reciprocal category. Off-site is a shipment made on behalf of a consumer who orders by phone, fax, or internet. On-site refers to shipments made for a customer who is placing the order while visiting the winery's tasting room. There is a provision that allows wine purchased while visiting a winery to be shipped to another state. Purchases must go along with the state law that determines how much wine a consumer could have legally carried back themselves. That is the amount of wine that a winery is now able to ship to the consumer. It is never legal for an individual to ship wine. The U.S. Postal Service will not carry alcohol under any circumstances. Both FedEx and UPS have company policies that strictly prohibit accepting alcohol shipments from individuals for delivery. These rules are based on their requirement that only entities who have signed a wine shippers agreement, which has special provisions regarding liability and packaging requirements, as well as reporting components for deliveries into the other states. These agreements are only available to licensed alcohol retailers and wineries themselves. A primary reason for this is also the special handling and adult signature requirements that are required for alcohol deliveries. The goal is to avoid any possibility of a package being delivered into the hands of a minor. Packages shipped under the wine agreements have to meet rigorous labeling standards and cannot be handled in the normal default manner of other packages. For example, adult signature over 21 years of age is required for delivery. There can be no signature waiver, and packages cannot be left even with a consumer signature request. The delivery must be made in person so ID can be checked. Most states do not allow shipments from individuals to enter their state. Regardless of these rules, though, the carriers do not make such shipments. Exporting wine. Export documents and certificates. Various export certificates are documents that are often required in order for alcohol beverage products to be imported into a foreign market include Certificate of Free Sale, Certificate of Origin and/or Age, Certificate of Health, Certificate of Sanitation, Certificate of Authenticity, Sanitary Statement Certificate. Each shipment of wine that is being exported requires a separate export certificate, a certificate of origin, age, health certificate, etc. One certificate can cover several different wines as long as they are in the same shipment. Export certificates are not licenses. They are documents that attest to certain facts. For example, a certificate of free sale confirms that the wine being exported was made in accordance with U.S. winemaking practices and is freely available in the U.S. marketplace. Certificates of origin are also often referred to as certificates of free sale. Your local Chamber of Commerce may process certificates of origin attesting that the alcohol beverage to be exported was produced in the United States. A number of countries have unique certificate requirements. TTB maintains a link to a list of international import-export requirements on their website. However, Countries may change their requirements at any time, so they recommend that you contact your foreign importer to confirm which certificates are required by that country's government. Exporting wine to the EU. U.S. wine exported to European Union or EU countries must be accompanied by a VI1 form, which certifies that the wine being exported, 1, complies with the conditions governing the production and entry into circulation applicable in the United States of America, 2, has been produced using enological practices in accordance with the terms of the EC-US Agreement on Trade in Wine, and 3, has been produced by a winery licensed by the TTB for the production of grape wine. The VI1 form serves as a certificate of analysis and compliance with EU regulations in regard to enological practices. A laboratory chemist or enologist that has been certified by the TTB must conduct the wine analysis. Instead of using the VI1 form, the TTB encourages U.S. exporters of wine to the EU to take advantage of the simplified export certificate, which only requires one chemical analysis of the wine, actual alcohol content, and is self-certified by the exporter. It does not require TTB approval. The self-certifying export certificate is a simplified version of previous certificates, VI1s, required by the EU. Names such as Chablis, Burgundy, Port, and Champagne are called semi-generics, and they have been in use on wine labels in the U.S. since the 1800s. U.S. winemakers have been legally permitted to use a group of 16 specific semi-generic terms on labels if accompanied by an adjacent appellation of origin. The new agreement allows for the continued use of these terms on existing brands, but not new brands. This addresses European concerns without diminishing the rights and investments that current U.S. brand owners have made in these terms over many decades.